The next witness in court might not be human. It might be a chatbot. And that raises a strange question. Can software accidentally create hearsay? Picture this. Someone asks an artificial intelligence tool for a legal filing deadline. Later, that answer shows up in court. Now the fight begins over what, exactly, that answer is. Under the federal evidence rules, hearsay depends on a declarant, and a declarant is a person. That makes ordinary machine output look different from human testimony. That distinction made sense for breath tests, GPS logs, or security timestamps. Those tools record events. They do not really speak. They are more like thermometers than witnesses. But generative artificial intelligence changes the feel of the problem. Chatbots answer in full sentences. They sound confident, conversational, even helpful. That human style can make weak information feel solid. The Pace article argues that old hearsay exceptions fit humans badly here. Excited utterances, present sense impressions, and dying declarations depend on human stress, perception, or belief. Machines do not have those states. And the black-letter rules sharpen the problem. Federal Rule of Evidence 801 says a statement is a person's assertion, and a declarant is the person who made it. If a chatbot outputs a sentence, the law can ask whether any human declarant exists inside that sentence at all, or whether the output is just machine-generated information. That is a clean doctrinal line on paper, but a messy one in practice when software produces natural language answers that sound exactly like testimony. Andrea Roth has spent years arguing that this is where evidence law starts to wobble. In machine testimony, she says courts have often forced machine output into awkward boxes. Sometimes courts treat it like hearsay, sometimes like real evidence, and sometimes just as the basis for an expert opinion. Her warning is that old categories do not fully let juries test machine credibility. And in later work, she argues evidence law still lacks meaningful ways to scrutinize information whose flaws cannot be exposed through ordinary cross-examination. Even business records raise trouble. A company may routinely save chatbot output, but trust still depends on how the system was built, trained, monitored, and used. That concern is not abstract. Stanford researchers found general-purpose large language models hallucinated in legal tasks at least 58% of the time. And when Stanford researchers tested leading AI legal research products marketed as more reliable, they still found notable error rates. Lexis plus AI and Ask Practical Law AI were wrong more than 17% of the time, and Westlaw's AI-assisted research hallucinated more than 34% of the time. In other words, legal AI may improve on general chatbots without becoming courtroom safe. That matters because generative systems do more than store data. They predict language. They can also accept a user's false premise and build a polished answer on top of it. So if a lawyer, witness, or party repeats a chatbot response in court, the danger is not just hearsay in the classic sense. It is manufactured authority. A sentence with no accountable speaker, no memory to probe, and no conscience to swear an oath. Legal scholar Andrea Roth has argued machine evidence needs special scrutiny because traditional safeguards target human flaws like memory, sincerity, and perception. You cannot cross-examine an algorithm the same way. So the real issue is policy. Courts can treat artificial intelligence as neutral machinery, or admit that some outputs behave more like testimony without being fully human. For now, the safest takeaway is simple. When artificial intelligence talks like a person, courts may need a new evidence category built for opacity, bias, and unanswerable confidence.